Thank you for tuning in to the Brach Eichler Talks podcast, where we explore and discuss today's trending legal topics. In this episode, we'll discuss a recent labor and employment alert from Brach Eichler titled, Employee Rights Expanded Under the NJ Worker Freedom from Employer Intimidation Act. Beginning December 2nd, 2025, a New Jersey employer may not require employees to attend employer-sponsored meetings, listen to speeches, or engage in communications that specifically express the employer's opinion about employees joining or supporting any political party or political, civic, community, fraternal, or labor organization or association, according to a recently enacted amendment to the state's Worker Freedom from Employer Intimidation Act. This law currently prohibits such employer-mandated meetings and communications about political and religious matters. New Jersey will now follow 12 other states which ban mandatory employee meetings about unionization. The law, as amended, does not prohibit employers from sponsoring such meetings when employee attendance is voluntary or from disseminating certain types of communications to employees. The law, though, does specify voluntary attendance will exist only when, prior to the meeting, the employer has so notified the employees and communicated that there will be no penalty for non-attendance. The amendment clarifies that an employer may 1. Communicate information that the employer is required by law to communicate. 2. Communicate information necessary for employees to perform their required job duties, including requiring attendance at a meeting or participation in communications. And 3. Require employees to attend training regarding unlawful workplace harassment or discrimination. As is common with many New Jersey workplace laws, employers must post a notice informing employees of their rights under the law in a conspicuous place commonly frequented by employees. The prohibition on mandatory employee meetings seems to run counter to the First Amendment and federal labor law, the latter which specifically provides that expressing of any views, argument, or opinion, or the dissemination thereof, whether in written, printed, graphic, or visual form, shall not constitute or be evidence of an unfair labor practice under any of the provisions of the National Labor Relations Act, if such expression contains no threat of reprisal or force or promise of benefit. Similar bans by other states have been challenged on those grounds. See e.g. Min. Chapter of Associated Builders and Contractors v. Ellison, No. 24-3168, Sir, September 3, 2025, NLRB v. Oregon, No. 6, Tours 20, CV 00203MK, Dior, September 27, 1, California Chamber of Commerce v. Bonta, No. 2, 24-003798, SCRED Cal, so far unsuccessfully. Nonetheless, New Jersey employers should remain current on any challenges to this newly enacted amendment. In the interim, New Jersey employers should carefully review their policies and practices to ensure compliance with the new amendments. Because of the potential risks and liability, we suggest that any employer conducting a meeting that could potentially touch upon a political matter first consult with legal counsel. For more information on your organization's obligations under the Worker Freedom from Employer Intimidation Act, please contact any member of the firm's Labor and Employment Practice Group. Anthony M. Rainone, Esquire, Member and Co-Chair, Labor and Employment Practice at 973-364-8372, or A. Rainone at brocheicler.com, or Matthew M. Collins, Esquire, Member and Co-Chair, Labor and Employment Practice at 973-403-3151, or mcollins at brocheicler.com, or Eric Magnelli, Esquire, Member Labor and Employment Practice at 973-403-310, or emagnelli at brocheicler.com, or J. Sabin, Esquire, Member Labor and Employment Practice at 917-596-8987, or J. Sabin at brocheicler.com. Or Michael A. Spizzuco, Esquire, Member, Labor and Employment Practice at 973-364-8342, or mspizzuco at brocheicler.com. Don't forget to subscribe to our podcast on Spotify, Apple Podcasts, and YouTube. Follow us on LinkedIn and Facebook for updates on new episodes. For more information and resources, visit brocheicler.com. This is intended to provide general information, not legal advice. Please contact the authors if you need specific legal advice. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey with over 80 attorneys. The firm is focused on the following practice areas: healthcare law, real estate, litigation, trusts and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property, and information technology, real estate tax appeals, tax and cannabis law.